to the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real-world impact with insights from top researchers. Today, we'll discuss about the notion of fairness, especially in the context of app stores, and in particular, the translation of FRAND conditions, so fair, reasonable, and non-discriminatory conditions, in the context of these app stores. And to do that, we have with us today Jorge Padilla, who's the chair of Complex Lexicon International, and you'll know him from a wide range of areas that he's participating on, from his numerous papers on competition policy and also industrial organization, and as well as his delivering of expert testimony before a large number of competition authorities and courts across several EU member states, before the Court of Justice and also before the European Commission. So welcome to the Agora, Jorge.
Thank you very much for the invitation. Pleasure being with you.
I wanted to zoom out a bit on the concept of fairness as we understand it in competition policy and economics. Your co-authored handbook, The Law and Economics of Article 102 of the treaty, alongside your colleague O'Donoghue, covers some of these manifestations of fairness depending on the type of conduct concerned within these types of abuses. So I wanted to ask you, first of all, whether you believe that there is a well-established theory of fairness across different types of behaviors in EU competition policy.
Thank you. Well, first, let me talk about fairness from the perspective of economics. Now, I think that most of us economists tend to say that economics is not about fairness, it's about efficiency, meaning that we care about the size of the pie, but not so much about how the pie is distributed. And I think that that's by and large true. But that doesn't mean that we economists don't have ideas about what fairness means or how a pie should be distributed in order to be qualified as a fair distribution. There is an entire field of economics, social choice and welfare, that deals with the issue of how to distribute the pie so that it is fair. Now, I think that I'll talk about that in a second, but the first thing I would say is that what we economists are kind of adverse is to the idea that any distribution matters, or that, better said, that distributions of the pie that kill the pie are distributions that can be regarded as fair. So even if we move beyond the size of the pie, efficiency, to talk about the distribution of the pie, fairness, there is a constraint in the way that we think about fairness, because we believe that if the distribution kills the pie, that may be fair in a sense, but is something undesirable. So, and this is important because in the contrast between fairness and welfare and aggregate welfare, economists are always going to try and defend welfare, are going to postulate welfare, efficiency, the size of. Having said so, what is that economics has to say about a fair distribution? There are many notions of fairness in economics, many notions and concepts. The one that I favor personally is the idea of the Shapley value, in honor of the Nobel Prize winner, Lloyd Shapley. And the Shapley value, the idea of the Shapley value is that the pie should be distributed in proportion to the relative contributions, incremental contributions made by each of the members of society that contribute to the formation of the pie. So if there is a pie to be distributed between you and I, Alba, and you are absolutely essential for the pie, and I am not essential for the pie, you should be taking 100%. Instead, if you and I are equally essential, then we would be getting 50% each. Of course, things get more complicated as you add individuals and you take into account that many of them may be essential, but essential in different ways. So the two of us may be essential for a contribution of 3, but alternatively, one of us may be dispensable. So 2 people are necessary for the pie to exist, but which 2 is not determined ex ante. So this is a way of saying that economics can indeed help us think about fairness. Now, the notion of fairness in competition law is related to the notion of fairness in economics, but not quite. The emphasis in competition law when thinking about fairness is to make sure that any action or initiative taken by a company that creates value allows consumers to enjoy part of the value created. Whereas in economics, the idea of fairness is anonymous. And what matters is what is your incremental contribution. in competition law, fairness is associated with the rights and entitlements of consumers. So consumers may have not done absolutely anything to create that value. That value may be the result of the investment of a firm. Still, in competition law, we want consumers to get part of that value, to be attributed part of that value. And that's why we consider that prices that extract all the rents from individuals may be excessive. That's why we consider that a merger that generates efficiencies at the expense of consumers is a merger that should be prohibited. So competition law is not anonymous anymore. The notion of fairness in competition law is associated to the idea that consumers deserve part of the pie that is generated in a competitive free market economy.
I was thinking whether this concept and notion of these rights and entitlements that consumers are really entitled to have, abiding by EU competition policy, the same concept of fairness that we can translate directly into the DMA, because the DMA is designed around these concepts of contestability and fairness. Bearing in mind that the DMA and economics do not match up quite well, whether you think that this is the same notion of fairness, or is there a different manifestation that we should take into account?
In my opinion, it's very similar, except that I think that we would be replacing end consumers with business customers. To the best of my understanding, in the DMA, we are talking about the relationship between gatekeepers and their business customers. And what we want to ensure with the DMA, that the pie that is generated in the interaction between the gatekeepers and the business customers is such that part of it is appropriated by the business customers and a part that reflects the value that they contribute. So for me, contrary actually to what you implied, the DMA is closer to the notion in economics than in a standard competition law. Because in a standard competition law, as I said, consumers are entitled to part of the pie, even if they don't make any contribution to the pie. In the DMA, what we're talking about are pies that are generated as a result of the collaborative effort, the cooperation between business customers and gatekeepers. And what we're trying to ascertain or determine is how that pie that is jointly created has to be shared between the two. So think about, for example, a concrete example. Let's think about app stores. App stores generate value because you have an app store and because you have apps. An app store without apps is valueless. Apps without an app store would be possibly less valuable because they would find it much more difficult to reach out to end consumers. So the value of the app store is a joint creation of the app developers and the app store owner. And when we think about fairness in that context, what we're thinking is how each of them should be rewarded. What is the proportion of that pie that should be appropriated by each of these players? And in economics, the notion would be, well, let's look at what are their incremental contributions, how the pie has increased as a result of the contribution of each of them, so that then we can distribute that aggregate pie that is now larger, that increase in the pie between the different parties. So I actually think that the notion of fairness in the DMA is actually quite close, in my opinion, to that in economics.
Descending this broad objective of fairness into the practical sphere of the DMA's application, as you were saying, the DMA provides for these opportunities, for instance, via Article 612, which establishes that app stores, also online search engines and online social networking services, shall apply these FRAND general conditions of access to business users. On a recent paper that you authored alongside Kadambari Prasad, you formulate a proposal on how to apply that particular obligation in the context of these app stores. But before going into the nitty-gritty of that particular proposal that you frame within the paper, have the application of these FRAND conditions in the past worked in the context of competition policy, and how have those unfolded in practice, and whether there are indeed sound economic methodologies sustaining the establishment of this per se obligation upon the gatekeepers?
The notion of FRAND at theoretical level is relatively easy and is related to the notion of fairness that I mentioned before. In practice, it becomes much more complicated, of course, but that's not surprising. Everything in practice becomes much more complicated when you have to descend to the particularities of a case. To the best of my understanding, the notion of FRAND in competition law has been used in the past, but only to a limited extent. So we have, for example, we had a significant discussion about what should be the price of access to Microsoft's APIs in the context of the 2004 decision, at least the portion of that decision that concerns interoperability. And there was a very long discussion as to what should be the price, the access price to the APIs of Windows so that competitors in the workgroup server operating system market could effectively compete with Windows. And the discussion there had to do with the fact that a FRAND rate cannot be one that reflects the market power that has been, in a sense, entrenched as a result of anti-competitive behavior. That is a limited example. I think it is very telling because it tells us that when the Commission and Microsoft were debating about that access price, both of them were using arguments related to what is the incremental value of these APIs for these third-party competitors. What is that? What is the size of the pie? And which part of that pie is created by Microsoft, and therefore Microsoft should be entitled to be remunerated for. The concept of FRAND is very common in the area of standard essential patents. There, FRAND is part of every single conversation. And again, at the conceptual level, I think that there is a consensus that FRAND means there is a notion related to the incremental value of the technology. So a patent holder with a patent portfolio of standard essential patents should be entitled to remuneration that is commensurate with the incremental value that the technologies that are covered by those patents generate on the implementers of those technologies. The difficulty in standard essential patents is, again, that you don't want that incremental value to reflect the existence of market power. So we are a little bit like in the Microsoft situation. And that's why we talk in standard essential patents about ex-ante value before the standardization. In the case of Microsoft, we would be talking again about ex-ante value before Windows becomes indispensable. And the problem then is that in practice is that you may not have observations about the world without market power. And that's why we end up doing all sorts of other things in order to approximate that ideal concept of FRAND. In standard essential patents, you look at comparables. The problem always is whether these comparables are tainted because they also reflect market power. And sometimes we move away from comparables, either because they don't exist or because we believe that they are tainted. And then we come up with certain formulas aiming to approximate that incremental value. And as we speak, economists are trying to develop methodologies that allow to calculate that incremental value to the best extent possible on the basis of observables. And that's, in a sense, work in progress, both in standard essential patents and in other areas where we have similar problems.
Bearing in mind the problems that have taken place before the DMA was applicable and entered into force, especially in the context of app stores such as Google and Apple charging, for instance, these fees upon developers that some considered extractive for the operation of their ecosystem and also for their intermediation of transactions within the ecosystem. I would say that these observables will be quite challenging also to establish in the context of app stores. In fact, we have not really seen until now much attention being drawn to the establishment and the enshrining of these FRAND conditions of access. On the side of the European Commission, it seems that the European Commission is quite shy in trying to establish how those FRAND conditions are going to unfold in practice, and also on the side of gatekeepers, in the sense that within their compliance reports, they just say, we offer our services for free and we do not discriminate anyone from accessing such services, so our conditions of access are therefore FRAND. And I believe that it is much more complex to try to square that circle in the context of app stores because of this lack of observables. And I would be really glad if you could maybe walk us through the proposal that you set forth within this paper, co-authored with Kadambari Prasad, especially because I read through it and I thought that it was quite innovative in its approach, although it really built upon all of the experience, as you have said, about this incremental value that these services render, in this case, for the ecosystem in general.
Correct. Let me unpack your question in two parts. First, let me talk about the issue of should we use the DMA to regulate prices, because that's Article 612, or is that just a piece of decoration that is included there for the sake of making the DMA complete, but without any intention to enforce it? And secondly, let's talk about then, if we decide that we want to enforce 612, and we really are serious about FRAND pricing, then how do we do it in the context of, for example, app stores, and what are the complications? I think that competition agencies have been always very reluctant to enforce any excessive pricing regulation, Article 102A or their equivalents in the member states. That reluctance, to some extent, has been reduced over time. I think that especially national competition authorities have been much more active enforcing Article 102A and their equivalents over the years. The problem is that it is always complicated to determine what is a competitive price. And I understand that given that Article 102 and their national equivalents are kind of quasi-criminal provisions, one is cautious, or needs to be cautious about implementing Article 102A. There is no distortion of the competitive process. Basically, what the companies are doing is exercising the market power that they possess. If we consider that market power and the possession of market power is legitimate, it's not clear why they shouldn't behave as a company with market power, provided that they don't distort the competitive process. And I understand, therefore, that competition agencies look at excessive pricing or FRAND pricing with caution. But in Europe, regulatory agencies have, on the contrary, regulated prices on a regular basis. Regulating prices is, in a sense, the raison d'etre of energy regulators, telecom regulators, postal regulators, water regulators, and so on and so forth. Regulators do many things, but fundamentally, they regulate access to essential, indispensable assets that constitute natural monopolies, assets that, even if they may not be stricto sensu, or from an economics perspective, natural monopolies, still they're indispensable and difficult to replicate, and therefore difficult to operate or price under competitive conditions. Now, my understanding is that the DMA is not competition policy, although I know that there is an extensive debate about whether that is true or not, that the DMA is regulation. I don't understand that a regulator being shy about regulating. If a regulator tells me I don't want to regulate prices, then I wonder whether that is really a regulator or is a competition agency disguised as a regulator. You may recall this famous dichotomy between hedgehogs and foxes that Isaiah Berlin once discussed. So what are you, a hedgehog, a fox, or a fox disguised as a hedgehog? Regulators regulate, and they shouldn't be shy about regulating if they think that there is a reason to do so. And definitely, difficulty is not an excuse. Regulating the price of infrastructure is not easy. Regulating the price of telecom networks is not easy. Regulating the price and pricing conditions, access prices in electricity networks is not easy. And that's why we have specialized bodies that focus on those tasks. And to the extent that the regulation doesn't imply a quasi-criminal offense, you are regulating somebody, but you're not saying, hey, you are guilty of something. You're guilty of charging very high prices. All that you're saying is, hey, you're a gatekeeper. In the interest of society, we're going to restrict your freedom by compelling you to set certain prices, but we're not going to impose fines on you, and we're not going to treat you as a criminal. Then I see no problem whatsoever. So I don't think that the reluctance to set prices that is typical of competition agencies translates well into the DMA world. If DG Comp may be justified in being cautious when setting prices in the context of the enforcement of Article 102, I don't think that provides justification for being cautious in the enforcement of Article 612. The second part is, if we think now, let's now enforce 612. How do we do that? And let's do that by reference to app stores. Again, I think that our proposal is consistent with the notions of fairness in economics that I mentioned before, and also with the way that FRAND has been considered or applied in the world of standard essential patents and elsewhere. What we would think is, okay, look, what is the increment in the pie resulting from the interaction between the app store owner and the app developers? And we would say, okay, the app store generates value for the app developers, and the app developers generate some value for the app store. The app developers are better off because there is an app store that works very efficiently, that has a large customer base that allows them to reach out to lots of consumers. App developers benefit also from all the services that are provided by the app store in terms of updating, upgrading, payment services, perhaps, and so on and so forth. The app store benefits from the contribution of the app developers because an app store makes no sense if there are no apps. Although one has to recognize that different app developers will contribute different amounts of value to the app store. And at the same time, the app store may contribute differently to different types of app developers. Some app developers may actually reach out to consumers regardless whether they use App Store A or App Store B or no App Store. Others, on the contrary, really will be depending on being present in an App Store to basically have access to consumers. So the incremental value, in a sense, of the App Store to the app developers is all the value that the App Store generates to the app developers minus what the app developers generate to the App Store. And so when we observe situations of a two-way exchange, the incremental value has to be a net incremental value. Now, for this to be fair, this net incremental value has to be relative to a benchmark that we regard as competitive. And so you would say, well, it has to be the value generated by the App Store to the app developers relative to the next best alternative that those developers have. To simplify things, let me, for a moment, abstract from the value that the app developers generate to the App Store. And let's think, just for the sake of argument, that we are in a one-way street, that is only the App Store that generates value to the app developers. So in that case, what we would say is, value relative to what? Now, there may be some other app stores available, then would be relative to the other app stores. There may not be app stores available. So that would be, relative to distributing that app through the web, but not through an app store. That means that you're going to have a web app as opposed to a native app. And we know that there are differences in terms of user experience, etc. Okay, have we finished? Not really. Why? Because we need to think about whether that value relative to the alternative is driven by the merits of the App Store or is the result of the gatekeeper role of the App Store in question. And in principle, consistently with the principles of the DMA, we should eliminate the value associated to market power. The market power in the case of an app store, comes from network effects. The fact that that App Store has this gatekeeper role as a result of being available for a long period of time and being used by many people. So we will have to abstract from those network effects. That's going to be the much more complicated. That's going to be the complicated part of the exercise. Now, this is not novel. It maps one-to-one the notion of FRAND in the context of standard essential patents. In the case of standard essential patents, you have a patent holder. The equivalent is the App Store owner. It generates value to those that use that patent. The App Store generates value to those app developers. We consider FRAND in terms of the value generated over the next best alternative. So what if you were using another technology? What if you were using another distribution channel? So you see the parallelism. But we also want to remove market power. So we say before standardization, and here you would say before network effects have materialized. So it's a one-to-one mapping of the notion of FRAND that for which there is consensus from that notion to the world of app stores. Now, companies like Google and Apple, who are nominated as gatekeepers in the app store world, find themselves typically in the position of payers in the standard essential patent world. And they would endorse the notion of FRAND that I mentioned there. They wouldn't want to pay patent holders more than the incremental value that that patent brings to their products, the smartphones, in a world in which there is no market power. So in a world in which they could substitute those technologies for something else. What this proposal would be asking Apple and Google is to be internally consistent and apply the same principles and endorse the same principles when they are in the opposite position, when now they are the gatekeepers. Gatekeepers in standard essential patents are the patent holders. Now they would be the gatekeepers. And this proposal would say you should charge a value, an access price that is related to the incremental value of the next best alternative, but in this ideal world in which you don't have market power. And then the question is, how do we approximate that value in practice? But again, I think that we can. How? Exactly in the same way that we do in the world of standard essential patents, looking for appropriate comparables. And if we don't have appropriate comparables, then we will need to look for estimating that incremental value in a world in which there are no network effects. Much more complicated, definitely. Work in progress to some extent. But look, we're in the world of regulation. So experts coming from the regulator, with perhaps the help from academia, etc., can develop the appropriate methodologies. The comparables, by the way, just to conclude, are not impossible. For example, we may look at the evolution of access charges over time, and we may see how the gatekeeper, what were their access prices charged by the gatekeeper before it became a gatekeeper. If we're lucky in that respect, we are in the best of all possible worlds, because then we can create this ex ante incremental value of the next best alternative, which would mirror directly the notion in standard essential patents and would allow us to implement this notion without any hesitation and without any difficulty.
To finish off the discussion, I wanted to contribute with a short remark, in the sense that we must also not forget within this proposal of the incremental value that developers contribute to these ecosystems and to these app stores, that the DMA from a legal perspective is designed with a reversal of the burden of the proof or the burden of intervention against these gatekeepers. From the perspective and the theory of economics, I believe that there may be loads of game theory going on the gatekeepers' minds, in the sense that, okay, are we going to really stimulate the debate? Are we going to open Pandora's box to really establish what these FRAND conditions and what these FRAND fees will mean in practice? Or are we going to keep that box shut so that we don't have to really redistribute the and rents across all of the value chain? Because I believe that the incentives are well demonstrated as stemming from also the iterations that these gatekeepers have performed before competition authorities in the past. So I believe there's going to be much to be followed within the discussion, especially from the academic side. And I wanted to thank you, Jorge, for all of the discussion and from bringing all of these enlightening insights with regards to FRAND and how those are going to work. And that's a wrap for this episode. If you have any thoughts or any feedback, drop a comment below.
This paper that we have been discussing about is a paper that has not been sponsored by anyone. However, as you mentioned at the beginning, I work at Compass Lexicon International. Compass Lexicon has been representing some of the big tech companies in related issues. We have also been working sometimes opposite to some of these big tech companies also in related issues. And in particular, both Kadambari and myself work for Spotify during the litigation or the administrative proceedings investigation by the European Commission on Apple's conduct on app stores. That case didn't involve discussions about the level of these fees, but I think it is important that I disclose potential conflict.